So we are really understanding of the unique issues that startups face, especially when it comes to litigation. So just a brief agenda of what we'll be talking about today. First, we're going to go over pre-litigation and what to expect during that phase. Second, the life cycle of a lawsuit. Third, common startup pitfalls that Teresa and I have both witnessed in our practice. 4, ways to mitigate risk so that you don't fall into those pitfalls. And then we'll leave room for questions at the end. So first, we're going to talk about pre-litigation phase. And yes, we're tying a shoe. Teresa and I are both in St. Louis and thinking it's very cold out and it's hard to exercise right now. So we decided to stick with the sports themed. And right now you're lacing up. No trial has been set. No case has been filed. This is all the pre-litigation phase. So first thing that might trigger a pre-litigation phase to know that you're in the phase is a demand letter. So what is a demand letter? A demand letter is typically written by an attorney to your company that states a legal claim and damages that the company is seeking. Might say this is a breach of contract based off XYZ, and it might be a little scary because they're using legalese that you're not used to. So that's a demand letter. Often demand letters are sent, but they are not required to be sent. Typically, a company or an attorney will send a demand though before filing a lawsuit, as it's something that is done in good faith. This is also the opportunity for the company or the employee who's sending the demand to ask you for money. And many startups will choose to go ahead and pay the demand letter money because they want to avoid litigation if they think that it's a viable claim. So what to do if you receive a demand letter? First, don't simply ignore the demand letter. You don't want to just throw it in the trash and pretend that it didn't happen. This is something that you need to address, and you need to address it immediately. Second, you assess the validity of the demand letter's argument. You see, what is it claiming? Is it employee claiming harassment? Is there anything valid to that claim? Is it a breach of contract? Was there a contract even in place? Third, understand the motives for sending the demand letter. This is something that's done by looking at the party who's sending the letter. Is it someone that you know personally or a larger company that you have no connection to? Why would they be sending a demand letter? Fourth, consider hiring an attorney at this phase after you receive a demand letter. You can respond to a demand letter without an attorney, but of course, an attorney will assess the legal argument and really help you determine what's the next move. Should you respond right away? Should you wait a few days? What's next to do? Fifth, respond. And then sixth, continue working with your attorney or yourself to preserve any evidence. And we will get into what that evidence might entail later in this presentation. But of course, this is anything that's relating to the claims and the parties. I'm going to hand it over to Teresa.
Hi, everyone. It's a pleasure to be joining you today. Like Mary Kate said, we're going to start by talking about cease and desist letters. So as a primer, what is this letter? So this is a document sent to individuals or your business to stop allegedly illegal activity. That's the cease part. And then the desist part is to not restart it. Typically, we see these letters in our litigation around trademarks, but you can get a cease and desist letter for a variety of reasons. Like the demand letter, it's important to not throw it in the trash and forget about it because there are often deadlines in those letters that if you do not follow, then the other party will start a lawsuit, and we want to try and avoid that if we can, which is why we recommend that you consider consulting an attorney when deciding the course of action and responding to this type of letter. Now, when you consult with an attorney, typically we see 4 different types of paths. So the first is submitting a response letter. So we typically see this when the cease and desist letter reads like a frivolous harassment complaint and there's not really any serious merit to the letter. So an attorney might suggest that you completely reject the allegations of trademark infringement and respond to the letter outlining the legal and factual reasons for reaching this conclusion, and hopefully it will resolve there. A second strategy that your attorney might advise is to comply with the letter. So if you read the letter and you know that the trademark owner really has a slam dunk case against your company, your attorney might advise you to comply with the letter's demands. We see this a lot in terms of trademark cases where the cease and desist letter just says stop using our trademark and doesn't require any monetary settlement. A lot of times we'll see our clients say, okay, we're willing to do that because they don't want to have to pay any sort of money. Now, if they do want some money and you do think that you potentially had an issue, then we also recommend negotiation, which is where you can arrange some sort of settlement out of court so that you don't have to go through the litigation process and you can obtain a good result without having to spend too much on legal fees. Then the fourth option we see sometimes is filing suit. So if you feel that you have a really good case and that this is frivolous and you want to file a lawsuit, you can, and you can go on the offensive and ask the court for declaratory judgment, which means that if it's granted, effectively the court is stating that your mark does not infringe on the trademark owner's mark, and that's another way to end the litigation. So these are just 4 of the main options that you can see. Now, every case is different, so your case might not fall into one of these 4 options, but this is a good primer as to what are some potential strategies if you get a cease and desist letter.
Great, thank you, Teresa. Now we're going to move on to the life cycle of a lawsuit. So this is not exactly what you see on TV. A lawsuit, as many of you probably know, can take years to go through, and because it takes years, it can be quite costly, which is why we see a lot of our startup clients decide to settle the case before the lawsuit is filed, and that's through the demand letter phase or the cease and desist letter phase. So the lawsuit begins by being served with the summons and the complaint. The summons contains all the parties to the action with all the addresses, and then the complaint will have all the legal claims and allegations made by the opposing party. You will be served at the address of your registered agent, and we have a lot of clients that this might be a home address. So make sure that you're aware that you could receive service of a lawsuit at wherever this address is located. There is often and always a deadline to respond. Typically it's 30 days, but some jurisdictions have it 20 days or 40 days. And that's for you to respond and file an answer or another responsive pleading. And you might decide at this phase that you want to move to dismiss the claim, saying there's no reason why this claim should go forward. Or you might decide to bring a counterclaim, meaning that the other party has done something wrong as well, and you want to assert claims against them. You do not want to miss the deadline to respond, because if you do, this could lead to a default judgment, which means that the opposing party can go in front of the court and argue that they're entitled to all the relief that they are seeking because you failed to respond. So it's very important that you respond on time after you receive the complaint. And then, of course, representation. Teresa and I haven't been pushing attorneys just because we're attorneys. It's actually the law that a corporation cannot represent itself. So a corporation must hire an attorney to represent them in court. So I know that for startups, this can be problematic because obviously costs, but also for your startup business, you're usually very personally connected to your business. And many startups wish to represent themselves in court, but unfortunately you are required to have an attorney. So it's really important that you consult an attorney early on. And again, we recommend consulting an attorney as soon as you receive that demand letter or that cease and desist letter.
So next, after you have your initial pleadings filed, the case progresses with what we call discovery. And this is the time in which both sides can request information and documents from each other. And The courts generally allow a pretty broad range of requests because anything that is reasonably calculated to lead to the discovery of admissible evidence is discoverable. And because of that, it can be really difficult to comply with discovery. There can be substantial soft costs with time and effort taken away from business activity. There can be substantial hard costs with the amount of money and time that it takes to make sure that you are complying and producing everything that you need to. And this is where your attorney can help you again through this stage, because certain types of information may be protected, including any correspondence you have with your attorney. I wanted to provide you some examples of common discovery requests just to help you wrap your brain around what types of things we typically see. So typically, each party will ask for all communications between you and the company suing you, and communications are viewed pretty broadly. So it can be any letters sent through the mail, emails, any instant messages, text messages, really any sort of correspondence, meeting notes, anything can be discovered under this process, assuming that it's not protected by some sort of privilege. This will also include any business arrangements, those key documents, phone records, things like that. And to the extent that it involves you personally, it can also ask for personal information such as your home address, your phone number, your contact information, things like that. Typically, during the discovery process, depositions also occur. So a deposition is a witness's sworn out of court testimony. So that can be you as the founder, it can be one of your employees, it can be someone from the other side. And this testimony, although it's out of court, can be used at trial, and we'll touch on trial later. So at the deposition, though, since it's out of court, it doesn't directly involve the court. There won't be a judge there. It won't be in a courtroom. It'll typically occur in a conference room, and the people there will be the deponent, that's whose deposition is being taken, the attorneys for all of the parties involved in the litigation, a person to administer an oath, because as we stated earlier, it's a sworn statement. And then a court reporter will take down everything that is being said so that there is a record of it for trial later on. And then from there, the attorneys present can ask the deponent any questions. It's really difficult to object to any questions during the deposition. There are limited objections that are allowable, but for the most part, any question that you are asked during a deposition, you have to answer. So as the case nears the end of discovery, you'll often hear about motion practice, and that motions are brought before the court. It includes a writing regarding your position on a legal issue, and then your attorney will give an oral argument before a judge, and the judge will ultimately rule whether or not to grant your motion. They're typically for pretty limited but very contested issues, and they can be costly with all of the writing, legal research that goes into the motion, and then the time to prepare and present the oral argument. So a lot of times we see our startup clients near the end of discovery, motion practice is looming, trial is looming, where they consider settling through mediation before getting into this intense motion practice and trial. But some of our clients choose to progress on, go through a motion practice, and then the case will ultimately end at trial. So this is what a lot of us are familiar with. This is what we see on TV. It's the formal examination of evidence before a judge and or a jury to determine liability. And these can be pretty lengthy and expensive, and depending on the type of matter at issue, it can create some bad publicity. So those are issues that our clients take into account before determining whether or not they do want to go to trial. Specifically, we see with some patent cases that our firm handles that they also count how complex the patent is. A lot of times they're very complex technical issues that can be tough for a judge or a jury to understand, which can make it harder to prove your point in court. So that's another consideration. And then depending on what's at stake, there often is a reliance upon expert testimony. So there are costs associated with having experts write reports, costs associated with them presenting at trial. So there's a lot to think about when considering whether or not to take a case to trial. Another consideration is whether you want a bench trial or a jury trial. There are pros and cons to both, but a bench trial is where the judge will ultimately decide the case, and a jury trial, which is what we typically see on TV, is where a jury will hear the facts and the evidence and then ultimately make the determination. Typically, bench trials are cheaper and quicker because you don't have to have a jury involved, but it's ultimately up to you as the client to determine how you want your case to progress and eventually end. So I'll turn it over to Mary Kate to talk about some litigation issues we're currently seeing.
So we're currently seeing a rise in litigation for startups, and this is particularly seen when people start working on business plans and start developing IP before there's a formal company created and before formal contracts are signed. And that causes a lot of issues down the road. And we've seen this recently portrayed in The Social Network, as I'm sure many of you have seen that movie. So it's very important that prior to, planning everything, that you sit down and you form your corporation and you sign contracts with your employees and you sign contracts regarding your IP that will be created so that you can avoid litigation down the road. This litigation often occurs when the startup is in the growth stage, and that can be harmful for a startup, especially when you're finally getting off the ground and growing and then litigation hits you. So again, that's why we're having this presentation today, just because it's something to think about when you're starting out. And then we also believe COVID-19 will only increase startup litigation. For example, if you have a company that sells widgets, because there's been so many shipping delays, maybe those widgets are delayed due to COVID-19, and that can result in litigation. So we're seeing that it is not going to go away and that we anticipate more startup litigation in the future. Now I'm going to go over some common startup pitfalls that Teresa and I have seen just in our experience at Husch Blackwell. So one common pitfall is choosing the wrong company name that might be trademarked with another company, and you shouldn't be using that name, or forming the wrong type of company formation. Maybe you formed a sole proprietorship partnership when you should have formed an LLC. All those things are important to discuss with your attorney before you form your company. Another common pitfall is the lack of a contract, or just the lack of understanding of contract. This goes to contract many times applying to IP, or just not understanding, who owns the IP under the terms of a contract. Third, we've already gone over this, but ignoring pre-litigation letters. Fourth, lack of maintaining communications. As Teresa mentioned earlier, phone records, emails, Skype messages, all those types of communications are discoverable in litigation. So it's important that you maintain all those communications, all those text messages that you might have with your employees or a company you're doing business with. Another common pitfall is not having employment agreements for obvious reasons. And this is often overlooked because a lot of times your employee might be a good friend or a family member, and you might not think to have a formal employment agreement with them. Not requiring employees to sign confidentiality requirements. Obviously, that's portrayed in television a lot, but it's important that when it comes to IP and other protected information, employees know that that is confidential and cannot be shared outside the company. And then delay in obtaining attorney advice.
Now we want to provide you with some ways to mitigate risk and things that you can think about proactively so that you don't find yourself in a potential litigation situation. So first, from the very beginning, when you are creating your company, we suggest creating it as a corporation or an LLC to help reduce owner liability. Because generally speaking, the creditors of a business also cannot succeed in court against the founders and other investors of corporations and LLCs for unpaid debts because they are sheltered by their corporate status. Another thing that can help you avoid legal liability is being very careful with everything you write in an email or send in a text message. As we've talked about, any communication you send, if you were to have a litigation matter, could be discovered. So you want to make sure that everything you're writing is above board. We suggest when starting out to create a founder agreement. So this is a document involving a company with 2 or more founders to help specify the details of the development of the company, such as the share of ownership and guaranteed obligations of the different founders. When possible, we advise avoiding 50-50 ownership or equal ownership amongst all of the founders, because that can create problems down the road if there is litigation. But then you see a lot of what is covered in a founder agreement is very specific to each startup. So for example, buyback options for shares, if a founder is entitled to a salary, how voting and general decision-making will be done. So these are specific to each startup, but an attorney can help you craft this document and make sure that from the get-go, everyone's roles and responsibilities are well defined. We also wanted to touch on specific IP issues, as we see this happening a lot in our practice. So we strongly encourage you, when picking your company name, to do some preliminary research to avoid trademark infringement or domain name problems. You can hire an attorney to help you run a professional trademark search to ensure the name you choose is actually available to use. And we recommend this because it can help save you from those cease and desist letters that I discussed earlier, because you might be infringing on someone's trademark and not know it, but having this professional trademark search can be really helpful to know from the get-go. So I'm going to turn it over to Mary Kate now to talk about some employee-specific issues.
Thanks, Teresa. So as many of you probably know, federal and state laws prohibit employers from making hiring decisions based off protected categories that include gender, race, age, color, religion, and disability. So how does it apply to startups? Well, when you're interviewing potential employees, you have to be very careful about what questions you ask. That means you should avoid asking questions like, how old are you? Or what is your religion? Or even, where do you live? That can tell you a lot about someone that might be getting to some protected categories of information. And of course, here in St. Louis, our favorite question, where'd you go to high school, is really off limits for a potential employee interview because it can reveal many protected categories of information about that individual. In order to avoid employment issues, it's important to be formal with every employee contract. Even if it's a contract with your brother or a good friend, you still want to be very formal with that contract. Second, you should ensure that your employment documents all comply with state and federal law. And of course, we're going to tell you, you should have an attorney look over those employment documents before you issue them to your employee to sign. Third, consider yearly updates to your employee handbook to reflect changes in the law. Again, that's somewhere that an attorney could help you. And then, of course, consider signing non-compete and non-solicitation agreements regarding confidential information. And that's really key for startups, because what you guys are creating a lot of times is highly protected IP information that you don't want to get out. So you need to make sure that you have agreements in place to avoid confidential information somehow being leaked. I'm also going to talk to you about proper record keeping. It's really important to try to stay organized and maintain discoverable documents. I know that startups are in a difficult position because often there's not many of you at the company, but it is important to have something in place where you can maintain your formation documents, your employment documents, your financial records, and then of course, communications. I know that often your emails might get all deleted after a year, or your text messages get deleted when you get a new phone. But it's still important that you somehow maintain those, because if a lawsuit comes your way 2-3 years down the road, you might have really good text messages that are on your side that you'll want to show the court in order to get a ruling in your favor. But obviously, if you don't have those saved, then it can be problematic. Well, thank you all for joining us today. We hope you enjoyed our presentation. Hush Blackwell will be back on March 4th for our second round of our virtual Venture Cafe presentations, and we look forward to seeing you there. In the meantime, if you have any questions, please feel free to email Teresa and me. We're happy to talk to you and happy to follow up on any other questions from today's presentation.